Hello, my name is Rocco Beatrice. I'm the Managing Director for Estate Street Partners. Today we're going to talk about how to protect your assets from the nursing home. Exactly what is the nursing home all about? Well, Medicaid in 2005 was changed. It used to be 3-year look back. It's now 5-year look back. What that means is on the date that you file an application to receive assistance from the state to pay for your nursing home care, the state has a right to ask you questions about what did you do with your money for the past 60 months. You have to provide them with the records, bank account records, checking account records, deed to your house, all the records that are relevant to whether or not you had sufficient money within the past 60 months that you suddenly gave away to your children or you gave away without receiving anything back in exchange. In other words, you conducted a fraudulent conveyance in order for the state to pay for expenses that you should have been able to pay. The CATO Institute has recommended that for property, instead of being 5 years, to be 10 years, almost forever. So whatever you did 10 years ago can be brought back as money that you still own. Otherwise, you're going to be excluded from the nursing home. Why are these laws so stiff? Well, the state and the federal government run a program called Medicaid. The state gets funded 50%. The state provides, and with seniors overwhelming the system, Congress designed a system whereby if you have money, if you gave away money within the 60-month period, you can't go to the nursing home. Your kids or whoever it is has to pay for your nursing home care. Now, in any type of planning, whether it be income tax planning, estate planning, probate planning, asset protection planning, Medicaid planning, it's best done when the seas are calm. So if you are 60 years old, you should be thinking about eventually going into a nursing home and how, if you have any assets, to do it 5 years before. Planning for Medicaid or any type of planning usually involves your ability to say, I don't own any assets. I don't have a car. I don't have a bank account. I don't have any stocks. I don't own a home. I don't have any investment property. And be able to say it convincingly. I don't own it. And the only way you can't own is through a trust. The trust must be irrevocable. You must have an independent trustee. Cannot be anybody related to you. Can't be your daughter, your son, and be able to claim that you don't own it. You don't have any compelling reason to be able to dip into those assets. And let's face it, within a 5-year period, 60 months, let's say you had a house, you converted it to your daughter, you gave it away to your daughter you just changed the deed. You went to a lawyer and said, all you got to do is change the deed. Yeah, you changed the deed, but you conducted fraudulent conveyance. Medicaid is confiscatory. It looks back 60 months. If you sell a house, you can't go back 60 months later and say that you still own the house. If you did sell the house, where did the money go? If you gave it away, who'd you give it to? Did you file a gift tax return? Did you pay a tax? It all boils down to this. Any type of planning requires for you to give up your assets, divorce yourself from your money, be able to say, I don't own it. This is Rocco Beatrice, Managing Director for Estate Street Partners. For this article and more, please visit ultratrust.com.